A very good afternoon to all. I welcome our worthy speaker of today's webinar, Shri Gurminder Singh ji. I also welcome our principal ma'am, Dr. Simrat Kaur ji, our HOD sir, Joginder Paul ji, faculty member of different institutions, member of legal fraternity, my worthy colleague, and dear students. It is really a great privilege for me to welcome our honorable speaker, Shri Gurminder Singh ji, senior advocate and former additional advocate general, Punjab. I also feel pleasure in introducing him to the audience of this national virtual session on the topic, the concurrent remedy of trial court and higher judiciary in bail matter, a practical approach. It is a known fact that Shri Gurminder Singh ji is a versatile speaker and orator. On behalf of Govt Mohindra College, Patiala, I once more extend a heartiest welcome to you, sir. I would like to please carry on his envisioning talk. Shri Gurminder Singh ji.
Good afternoon, everyone. Today it's a pleasure to be on this webinar organized by the Mohindra College Patiala, and this is actually a new platform for sharing information and sharing all the fields in which everyone has been working for many years but has not got a chance to share his views with everyone. Now, today I have been asked by Professor Jagmohan and the team to talk on the concurrent jurisdiction of bail, the broader concept and the practical view. Like we have seen, these webinars have also come into existence today because of the curtailment of movement outside our houses. And it is by this platform that we are able to share our views online. This curtailment in a manner also means that there is a restriction on our liberty to move around as we would want to. But today we are talking about a personal liberty in a different context, in the context of detention, arrest, and bail. As we all know that personal liberty enshrined in the Article 21, which mandates right to life and liberty, is a fundamental right of every human being. And detention and arrest in criminal jurisprudence curtail that right in accordance with law. Now, when a person is accused in an offense, during the investigation, the police or the investigating agency, as the case might be, want to detain and arrest him for the purposes of investigation and for eliciting evidence and for building up a case for prosecution of the accused. Now, there is a difference between imprisonment, as we all understand it, and arrest and detention during investigation or trial. Once a person is convicted, then the person has to undergo the sentence that has been imposed upon him. But before that, during the trial, the person can be detained for the purposes of investigation, even though not proven guilty as yet. The basic issue here is that the detention and arrest which is being done during investigation is not imprisonment. It is not a punishment. It is being done in accordance with law for the purposes of due and proper investigation to serve the ends of justice. So therefore, it is very necessary that there are checks and balances imposed in this investigation process, as also the detention and arrest of a person, so as to ensure that there is no undue curtailment to his personal liberty and freedom. So how do we understand the concept of bail? Bail is a temporary release of a person during investigation or trial with the conditions imposed upon him to secure his presence during the investigation or trial, so that if he is let out from custody on bail, the investigation or the trial is not hampered. Now, this is very different from, as I was explaining to you, from the suspension of sentence, which would come into play once the person has been convicted. The age-old idiom by Justice Krishna Iyer was that the rule should be bail and not jail, was because once a person is undergoing investigation, even when a person is challaned, even prima facie when he is found to be charged under an offense and subjected to trial, till the time that a person after trial has been convicted, he is not guilty. That is the rule of law. So till such time that a person has been proven guilty, can a person be detained? Yes, but actually that detention should only be limited to facilitate the investigation in the process. Now, there are two kinds of offenses which the law recognizes. The first are bailable offenses, and the second category is the non-bailable offenses. As we understand from the definition, that these offenses which are not so grievous and do not warrant the detention of a person are usually bailable, to which a police officer who is investigating the case can admit a person to bail. The second category of offenses are the non-bailable offenses, where the police officer does not have the power to admit a person on bail. A person has to apply to a court of competent jurisdiction to get the benefit of bail. Now, the court of competent jurisdiction, initially at the first stage, would be the court which is seized with the power to try the offense for which the person is accused. For instance, if a person is accused of an offense which warrants a magisterial trial, at the first instance, the person would be entitled to apply for bail on custody to the court which is going to try his offense. Now, this provision is contained under section 437 of the Criminal Procedure Code, where the magistrate is empowered to enlarge a person on bail for the offense, the trial of which he is competent to hold. Now, there is one condition where the magistrate cannot exercise this offense, where that offense is punishable by life imprisonment or by death. In those cases, the magistrate will not have the power to grant bail under 437, even though at the initial stage the commitment is done to him. Now, for these offenses which are non-bailable, there are two provisions which primarily are in criminal jurisprudence put to practice: the provisions under section 438 and the provisions under 439. Now, 438 is a provision where a person is apprehending an arrest but is yet not in custody. A person who is apprehending an arrest as an accused, or where he also has an apprehension that he is likely to be involved in a case resulting in his custody, can apply to the court under the provisions of section 438 for an anticipatory bail. As the word projects, an anticipatory bail is a bail sought from the court in anticipation of an arrest which has yet not been made. Now, there are various factors which will come into play when we are talking about the provisions of anticipatory bail and the court's discretion to grant it. First of all, there are two courts or two forums where anticipatory bail can be applied: the High Court of competent jurisdiction and the concerned Sessions Court, where the arrest is likely to be made or the cause of arrest has arisen. Now, when a person makes an application for bail for anticipation, where he is anticipating his arrest, the court will go into various factors to see whether that person is entitled to bail or not, which could be the gravity of the offense, the seriousness of the offense, the severity of the offense with which he has been charged or is likely to be charged. Then is the conduct of the person who is seeking bail. Is he a repeated offender? Is he a previous convict? Is he involved in many other cases which are pending investigation? All these things would also weigh with the court while examining the concession of bail, which is to be granted or not to be granted to him. The third very important thing is the propensity of the accused to flee from justice in case he is granted bail. Now, this is a very important aspect of the criminal jurisprudence, where a person is granted bail so as to not to keep him in custody while the investigation or the trial is going on, but that bail is not granted so as to allow him to escape the process of justice to which he has to commit himself. So therefore, there are a large number of parameters which the court goes into and then grants bail on certain conditions so that the person is not in custody but will subject himself to the investigation or trial. Now, a person who is accused of an offense or has been caught in the act of crime, it is very obvious that once he is caught, he wants to escape the process of law because of the fear of punishment, because of the fear of incarceration, because of the fear of being committed to jail, or even the fear of being hung or otherwise dealt with death penalty. So this becomes another reason for the under trial, once granted bail, to try and escape the process of justice. So therefore, the court has the power to impose conditions while granting bail so as to ensure that the person commits himself to the trial as and when he is charged for that offense. But there is another ground on which the court will also grant bail, which is codified in section 438 and which has become pretty much of a norm these days, where a person is being maliciously prosecuted for the purposes of causing his arrest. So many times we have heard of malicious prosecution, false FIRs being registered against certain people, whether for political interests, financial interests, personal vendetta. All these reasons may result in registration of an FIR which is not actually based on concrete or true facts. So the code also takes care of those circumstances where a malicious prosecution to cause the arrest of a person becomes the reason. A person can be enlarged on bail so as to save him from this persecution. And those conditions which the court imposes can include the filling up of a bail bond, surety, or a personal bond, whichever the court finds fit. However, the law also requires that these conditions should not be excessive, because the idea is not to burden a man, but to secure his presence. Now we come to the very important provision of bail, which is under 439. This bail is different from the anticipatory bail because this can be applied for only when a person is in custody. This bail will become available to a person who has been taken into custody by the investigation agency, or he has come and surrendered before the investigation agency, or he has surrendered himself before the court and is taken into custody, where the custody could be of two ways. One would be either he would be remanded to police custody for the purposes of investigation, or if the investigating agency does not require this person for further investigation, then the person is relegated to judicial custody, awaiting his enlargement on bail or awaiting his trial. Now, when a person is taken in custody, he applies to the court of competent jurisdiction for bail. Here also, two forums have been provided, the High Court and the Sessions Court, which can entertain and grant bail to the person when he is in custody for a non-bailable offense. The court is also enjoined with two additional powers. One power being that if a person has already been granted bail by the magistrate, but he has been committed to the Court of Sessions for a trial where life imprisonment or death penalty is the offence's prescribed penalty, then the court can also alter the conditions of bail which have been enjoined by the magistrate in his order. Those conditions can be altered. They can be increased, decreased, or set aside by the Court of Sessions or the Court of High Court. And also in 439, there is a provision for cancellation of bail. Now, this provision is very sparsely to be put into practice and to be judicially exercised, because once a court of competent jurisdiction has taken into account all the parameters and granted bail to a person awaiting trial, then for cancellation of bail, a very different set of factors will come in. For instance, if a person is enlarged on bail, we have seen many instances, we read in the newspapers every day, that if a person is enlarged on bail in a murder case, he goes back and he will commit another crime, sometimes even that of another murder, so as to settle scores with the person because of whom he is in custody or who has registered an FIR. Old enmity or personal enmity will come to the fore if a person is yet again released into the society and is confronted with the person with whom he has that enmity, prompting him to commit another offense. Second, where we see, for instance, one is that the person goes back and commits another crime. The second is intimidation of witnesses. We have seen this happening in acid victims case, in rape cases, molestation cases, where the accused has been released on bail on certain conditions, and he goes back and commits another crime on the victim so as to intimidate the witnesses not to depose against him. So therefore, all these conditions would become factors for cancellation of the bail when a person has been so released on it. Now we come to a very important factor, which is the gist of the discussion for today. That as regards bail is concerned, what is the court of competent jurisdiction to entertain an application for bail and release a person on bail? Now, when the legislature has framed these provisions in the Criminal Procedure Code, it has consciously taken upon itself to grant this power to two courts, two forums, two judicial authorities, the High Court as well as the Sessions Court. The wisdom of the legislature is possibly emanating from the fact that wherever the cases so warrant, the Sessions Court will have the power to grant bail, but in exceptional cases or in cases where the interference is so required, a superior court like the High Court should also have a concurrent jurisdiction for grant of bail. Now, what is the meaning of the word concurrent? Concurrent is when two things coexist, when they exist side by side, meaning thereby to say that the power which has been granted for release of an accused on bail is not higher or lower with the authority that is exercising. It is not that the High Court exercises a superior power while granting bail, or the Sessions Court exercises an inferior power while granting the bail. The power is equal, but the power is coexisting. For instance, there are other provisions in the CRPC, like Section 399, where the power of revision is there. There also two forums have been prescribed, the High Court and the Court of Sessions, to entertain. But if a person chooses one forum to exercise his right, the other authority, that means in case of the Sessions Court having been invoked the High Court, or the High Court having been invoked the Sessions Court, will not entertain the second application for revision. So once you exercise a right, the other forum stands closed and forfeited as far as the exercise of that right is concerned. But in the provisions of bail, such a foreclosure is not envisaged. Both the authorities can be approached by the accused for application for grant of bail. Now, basically, the legislature has left the working out of propriety and procedural propriety to the forums which have been enjoined with this power, meaning thereby that though the accused has a right to approach any of the two forums which are prescribed under law, such a power cannot be said to be unfettered. It is not that in every case, the accused can go and approach the higher court for grant of bail. So by practice and by precedent, the courts have put into place a system where there is a court of subordinate jurisdiction available, in this case being the Sessions Court. The person at first instance will go and approach the Sessions Court in which the cause of arrest or detention has occurred. It is only after the Sessions Court has applied its mind, either granting or rejecting bail. In case of rejection, a person can come to the High Court and make an application for bail. Now, here we need to understand something very important. That is, that if a person has made an application for grant of bail to the Sessions Court and the Sessions Court declines to interfere, then can a person make a second application to the Court of Sessions, or he has to come to the High Court to get bail granted? The law is that a successive application can be made to the same court, for instance, the Sessions Court, in case fresh facts arise for the grant of bail. Fresh facts could include that some evidence comes to light on the basis of which the accused becomes entitled for grant of bail. During trial, the key witnesses come and depose, where the deposition makes the accused entitled for bail. In these circumstances, the court can yet again apply its mind and entertain the application for bail. Now, when the person goes to the High Court after seeking his remedy in the Sessions Court, he is not going in appeal against the order, as is the case in other matters, like in civil matters, or like in other criminal matters where there is revisional or appellate jurisdiction conferred on the High Court. The person is going and exercising his right in a concurrent jurisdiction. The only difference in this situation being that the High Court will have the benefit of the order of the trial court. The High Court will have the benefit of the application of mind by the Sessions Court. And the High Court will independently, taking into consideration the right of the petitioner, the grounds of the petitioner, as also the grounds taken by the Sessions Court to reject the bail, take an independent call on whether the accused is entitled to bail or not. So therefore, we have to understand that in concurrent jurisdiction, the power which is being exercised is neither appellate nor revisional. When the Sessions Court has applied its mind, it is only with a view so that effective assistance can be rendered to the High Court to arrive at a conclusion. So therefore, both these jurisdictions have to be exercised by both the courts competent in law independently and are not overlapping. We have seen many cases where the accused directly go to the High Court because the stakes in the matter are high. Because the persons who are seeking bail are being subjected to political vendetta, multiple FIRs being registered. Now, I will just give you some instances where the High Court can, or some considerations where the High Court can directly entertain an application for bail. Suppose, for instance, the accused is accused of having committed crimes all over the state, which fall under various sessions divisions. Then he will not go and apply multiple bail applications in various sessions divisions. He will then come to the High Court and say that here is a case where multiple FIRs being registered against all over Punjab for a financial fraud or for some other instance or a transaction. So I have come to the High Court so that everything can be heard at one place and my rights can be decided. Or political persecution, where a person is on a run because the powers that be are trying to falsely implicate him in various FIRs. Now, there is a very important aspect of law where power to detain is under specific laws or even under the CRPC or the IPC, where the provisions of law are being challenged. There also the person can come and say that I want the court to examine the provisions of law. And while you are examining the provisions of law, kindly stay my arrest because I am challenging the very basis or the very statute under which I am sought to be arrested. So therefore, we also have bail prayers being made or stay of arrest prayers being made in writ petitions filed under Article 226. Because the person is saying that I want to challenge the law as also the effect of that law on me, which will result in my detention. So a separate aspect is there where under Article 226, courts are entertaining petitions and granting a stay of arrest while the proceedings are being entertained to examine the veracity of that law. But normally, the approach of the court is that frog leaping should not be allowed. That a person should not be allowed to leap over the Sessions Court to the High Court and straight away come for redressal of his grievance, because judicial propriety would demand that once there is a court available of subordinate jurisdiction, you should entertain that remedy first. Because the High Court cannot be flooded with litigation of bail applications at the first instance. A large number of people are allowed bail by the Sessions Court. They will not come and burden the High Court. They will not come and file proceedings before the High Court, therefore saving the High Court from burdening as far as bail applications are concerned. A very interesting aspect of this, I must share with you, is entertainment of bail applications by the Supreme Court. Now, lately we have heard instances of Arnab Goswami and of Vinod Dua, who are journalists, having approached the Supreme Court directly, alleging a violation of their fundamental right to speech, freedom of speech. And while taking that issue up with the Supreme Court, they have made an allied prayer that various FIRs all over India are being registered by a particular political party against me. Therefore, in all those FIRs which are being registered, kindly stay my arrest till such time that you examine that whether the offenses which I am being accused of are in contravention of my fundamental right or not. So therefore, various aspects of bail have opened up with precedents. There is a provision for transit bail where a person may apply in one state, say that an FIR has been registered in Bombay, please allow me the benefit of transit bail from Chandigarh to Bombay so that they don't arrest me on the way. So bail can also be applied in a different High Court. To take transit bail to go to the competent High Court or the Sessions Court to apply for bail. Then there are instances of blanket bail where no FIR has been registered but a person is being persecuted politically or otherwise. And a person says that whenever they register an FIR against me, give me 3 days notice or 7 days notice so as to allow me to avail my remedy of bail under law. So it is a very vast subject, but I'm just today trying to give you the basics of why the concurrent jurisdiction and what is the practical aspect of this which the courts take into consideration while entertaining an application for bail. So it has been actually a very, very informative preparation for me. I have had the occasion to look through law. I don't need to tell you the judgments because today every student has judgments accessible to him on the click of a button on a laptop. But there are certain questions which have arisen when this topic has been circulated. One of them was that why is it difficult to secure bail in an Ndps case? Now, as we all know, that drugs are eating away the core of our system. The youngsters are being exposed to this nefarious activity and lots of people are losing their lives in drugs, and to control this, the Narcotic and Psychotropic Substances Act was made. Very stringent provisions were made in this act as regards the grant of bail. Two particular sections are section 32A and section 37, where at the initial stage and after conviction, the act provides that no court will grant bail. This was examined, especially the provisions of section 37. where the court said in reference to the stringent provisions that you cannot take away the right of a competent court to grant bail or to deny bail. You will see the severity of an offense. You will most certainly see the facts of the case, but you will still give the power to the High Court or the competent court to grant bail in cases where it so thinks fit. So it is in this light where the statute provides very stringent provisions in NDPS that the bail or grant of bail becomes a very difficult remedy to pursue. The second question was that what is the adverse impact of bail on investigation? Very interesting question. If bail is the rule, then how can we say that bail is in conflict with investigation? It is a matter of common knowledge that if the policeman calls a person to the police station in context of an investigation in which he is likely to be arraigned as an accused or is already an accused, the person has the tendency at first to deny, to say, I am not connected with this offense, I am not involved with this offense, I have been falsely implicated. When suppose it is a financial fraud, let us take an example. It is a financial fraud and the person is seeking bail and certain documents are in his possession or certain evidence is in his possession, or say in a murder case where the weapon of offense has not been discovered. In those cases, the police wants to investigate further and wants evidence. When the person is free, when the person is unfettered, unchained, unleashed, he is not going to come and say that I have hidden the weapon of offense in a particular place, or where did I hatch the conspiracy, where are the documents connected with the offense. This gives rise to one concept called custodial interrogation. For these offenses, the police needs to take him in custody so that he doesn't destroy the evidence. He doesn't go and throw the, say, weapon of offense into a canal where it can never be discovered, and then link the chain of evidence to the accused so as to make sure that his conviction in case he is found guilty is ascertained. So therefore, now when we talk about adverse impact of bail is, if a person is enlarged on bail, we are to ensure that he does not go and intimidate the witnesses, destroy the evidence, or go and try and flee from justice so that to not join investigation ever again, which will become a problem. The third question, very relevant question, was that denial of bail to the poor. The poor people who are also convicted of very serious offenses, for instance, murder, rape, or for theft, or for other offenses which under the IPC, a person can be detained and booked and put into custody for. Whenever a person is granted bail, the CRPC says that a person is to submit some sort of a surety or a bond for his release to the satisfaction of the court which is releasing him on bail. In case the person is to be enlarged on bail, the conditions don't have to be so stringent. Suppose 50,000 bail is imposed on a poor person, then a person cannot afford 50,000 rupees or does not have the surety of the like amount and will still remain in custody in spite of having been granted bail. So here we have to see the provisions regarding the conditions imposed. So this is more or less what I have to say. And now I would request if anybody has any further query, or we can wind up the session. Thank you very much.
Thank you very much, sir. I personally indebted to you for your kind cooperation in this virtual session. Being a coordinator of this virtual session on the behalf of the college principal, the faculty of law and the members registered who participated in this virtual session, I thank you very much for this incisive discussion and discourse. And we are going to organize another seminar on custodial deaths, and I seek your cooperation in that seminar also. Thank you very much, sir.